Varadi ma'am, you are there?
हाय, मी आहेच रे जितेंद्र, कधीच केलं लॉगिन. We are starting.
Madam has not joined yet, na?
MKLMs, BLM non-ecology.
केलास का फोन?
नाही लागत आहे, फोन उचलत नाही.
ती करते म्हणाली जॉईन, असं मला म्हणाली. तेवढा पुढे वेळ वाढेल ना तुम्हाला. किती मुलं आहेत? कोणत्या इयरची आहे? जी तू लॉची आहेत की कॉमर्सची आहेत आपली?
कॉमर्स. मी परत एकदा फोन करतो, थांबा.
हा कर.
We'll be starting in next 2 minutes. Students, we wait.
काय झालं जीतू?
ते 2 मिनिटं लागणार आहे.
येऊ दे.
पानी गरम की जाता है.
Hello, good morning. Am I audible? Hello, Rajashri ma'am.
Yes.
Yes. I have joined now.
Yeah.
So good morning to all of you. Good morning, Jitendra sir.
Yeah. Shantaram, now mute everyone and start.
Yes, sir. Girls, it is a humble request to mute yourself. Do not unmute in between. Sir, shall we begin with?
Yes.
आणि
Yeah.
एक मिनिट जितेंद्र, तू फोटो सगळ्यांचा ग्रुप फोटो एक सुरुवातीलाच घेऊन टाक, कारण
ते
नंतर
आता
एक-एक
युट्यूब
जातील.
लाईव्ह आहे ना, फोटो तर युट्यूबवर सगळं असतं.
ओके ओके, चालेल. तुला घ्यायचा असेल तर. चला.
Yeah. So, very good morning, one and all present here. I am Shantam here. I would like to welcome each and everyone for our today's section, 1 week certification course on human rights, which has been jointly organized by University of Mumbai Department of Law, University of Mumbai Law Academic, and MKLM's Elimination College of Commerce and Economics, and Athwani College of Arts. I welcome you for our today's first day section, which has been holding by our three collaboration introduction. For the inaugural address, I would like to welcome and I would request Dr. Jitendra Ahirkar sir to enlighten us about the concept. Over to you, sir.
Thank you so much. At the outset, I would like to congratulate both the institution collaborating with us, Department of Law, University of Mumbai, and University of Mumbai Law Academy, in collaboration with BL Amlani College of Commerce and Economics, and students from various law colleges, especially from HPPS Law College. They are here today. Some part of the students from KC, some part of the students from other law institutions, and some faculty members are also doing this coursework because for CAS promotion, it is important to have 1 week certificate course certificate with you. So each and everyone who are present here, on behalf of all the three institutions, I would like to welcome you. I would also like to welcome Dr. Ashi Varadi ma'am, Professor, Department of Law, University of Mumbai. Dr. Swati Rautela ma'am, Head Department of Law, University of Mumbai. The faculty colleagues of the department, and the overall resource persons for 7 days who are going to give their best and immense knowledge and expertise in the field of law. The vision of doing this certificate course on human rights is the university or the NAC, National Assessment and Accreditation Council, had made mandatory that students should know about the universal human values, universal human rights, so that basically being a commerce college, we lag behind with all these programs because we don't teach human rights in our curriculum, human values in our curriculum. So we are very fortunate enough that we are associated with Department of Law, University of Mumbai Law Academy, and I can say two immense people who are here today, Dr. Rajshri Varadi ma'am and Swati Rautela ma'am. Girls, they are always there to support us. Their blessings are always there with us. I can say, because you must have seen these members in our college also. They come regularly and frequently. So when it comes to Universal Human Values Cell and human rights program, we can proudly say that yes, University of Mumbai department always help us for doing all the law related activities. So we can tap our shoulder by ourselves and we can say that yes, we are proudly associated with departments and they are always there to help. Thank you so much, ma'am. Now I request Dr. Raishi Varadi ma'am, Professor, Department of Law, University of Mumbai, to kindly give opening remarks.
Good morning, everyone. Dr. Swati Rautela, Head of the Department, my dear colleague from the department, my other colleagues, Dr. Sanjay Jadhav, Dr. Alka Patil, Mrs. Dipali Patil, Mr. Sheetal Sethia, and our host here, Dr. Jitendra Ahirkar, most vibrant and dynamic principal of Amlani College of Commerce. Dear students, non-teaching staff of Department of Law, UMLA and Amlani College, teachers of UMLA and visiting professors of Law Department, other college teachers from other law colleges, KC Law College, HVPS, our other colleagues, Hearty welcome to everyone here in this August gathering. I congratulate Dr. Jitendra Aherkar, Dr. Swati Rautela for organizing such a wonderful program, and that's too for 1 week on the theme of human rights. We are creating human rights education awareness, which is prime role of all education institutions now. My dear students, as everyone is aware, human rights are rights related to life, liberty, and dignity of the individual. They are universal, inalienable, they are indivisible, they are interdependent. Such rights are available to every person, every human being by their birth. Indian Constitution guarantees us several fundamental rights which are also given to us under human rights by UDHR, such as right to equality, no discrimination on the grounds of race, caste, sex, equality of opportunity, right to freedom, right to life and liberty, prohibition of traffic in human beings and forced labor, freedom of conscience and free profession, practice and propagation of religion, and so on. My dear friends, we are enjoying all kinds of human rights. These are required for the fullest development of every human being. When these human rights are available, and if there is a violation of human right, then how to protect it? We have machinery set up. Human Rights Protection Act 1993 is passed here. And under that machinery is set up, we have State Human Rights Commission, National Human Rights Commission. And courts are there, which protects human rights of people. When anywhere they find it out, violation of human right, one can file case before the court, such as nowadays. You must have observed that public interest litigations are there filed before the court, and several times court passes order and they go beyond the books of law. Like that, so many PIL are there. I'm going to discuss here some of the important landmark cases and decisions given by the Supreme Court of India. Just to explain you about the role of judiciary in protection of human rights. We have several legislations passed in India, such as Domestic Violence Act 2005, the Maintenance and Welfare of Parents and Senior Citizens Act 2007, Information Technology Act, Hindu Adoption and Maintenance Act, Dowry Prohibition Act, Immoral Traffic Act. So many acts, several acts are there. And we have courts, machinery, commissions are there, tribunals are there. Several commissions are there. If any cases they find it before them, they just make a scrutiny, and after going through the inquiry, they pass appropriate orders. Our State Human Rights Commission is so sensitive, sometimes they take so much to action to give justice to common citizens. These all are based on international conventions. We are aware of United Nations Charter 1945, International Bill of Rights, Universal Declaration of Human Rights 1948, International Covenant for Civil and Political Rights, 1966, International Covenant for Economic, Social, and Cultural Rights, which gives us plenty of rights, which by which we use all kind of economic, social, cultural freedom, right to organize programs, right to participate in election process, right to contest election. No, we have also Convention on the Rights of the Child for the protection of the rights of the child. Several number of conventions are there by which our rights are protected. Several rights are given to citizens of India. If anywhere such rights are violated, as you can file a case before the court, there are 4 writs available for the citizens: habeas corpus, mandamus, prohibition, quo warranto, certiorari. These writs are there. Habeas corpus is the writ by which if anyone files a case, then court passes order to produce the person before the court within 24 hours. Mandamus writ is issued when the court finds that a particular office holder is not doing legal duty and thereby it's infringing on the rights of an individual. Like that, other important writs are there. My friends, when any violation of human rights is there, as I say, you can file a case. I wish to discuss few important cases. As we have less time, my other colleagues are there who are going to address you. I wish to quote few of the important cases, in which first case I wish to introduce. And I think last time when I had been to your college, I have discussed about Air India versus Nargis Mirza. In this case, it was held by the Supreme Court that discriminatory service conditions levied on women employee are arbitrary in nature, and therefore it declares as null and void. Petitioner was reinstated in her service. This Nargis Mirza was an air hostess, and as per rules of the Air India, air hostess can work up to 35 years of age. After the attending age of 35, automatically her services were terminated, and her age of retirement may be extended up to 45 if her superintendent gives report about her excellent service. And if she becomes pregnant, then automatically her services will get terminated as per rules of the Air India. And when this hearing was going on, Supreme Court was very much upset by looking at the scenario, and they say these are natural rights available to women and one cannot take it away. No one is having such right, and they cannot put restrictions. If woman delivers a child immediately, she will be thrown out of services, and that is why these are arbitrary in nature, which were declared as null and void. In one another case, similar, CB Muthamma versus Union of India, similar thing happens where similar kind of conditions were laid down by Union of India, and court held that these are not proper. And even CB Muthamma, when she has applied for the service and when she joins the service, there was a condition that if she becomes pregnant, she will be thrown out of service. Same thing happens, and she says, why such things are levied for woman employee only? This is natural right available to every woman to become a mother, and she has challenged it, and court declares such rule as null and void, and CB Muthamma was reinstated in services. In another case of Srimati Selvi versus State of Karnataka, it was held by the Supreme Court that brain mapping narco-analysis, lie detection tests are unconstitutional as it violates fundamental rights guaranteed by Article 23 of Indian Constitution. These techniques cannot be forced on any individual without his or her consent. You are aware that these are new techniques used by the police to find out the truth, to find out the evidence in any criminal case. So, Supreme Court stated that only when the person gives his or her consent to such tests, then only the material obtained from such tests can be treated as evidence and can be read in court of law. In Nilabati Behera versus State of Orissa, one another important case, it was held that son of Nilabati Behera was taken into custody by police. One evening, they just take him to custody that we wish to make inquiry, and police take him away, and she has waited for next morning. In the night time, this boy did not return back. Next morning also boy did not return back, and mother was really worrying about him. What happened? What must have happened? Then anyhow, she collected some neighbors and she had given visit to nearby police station and say, yesterday evening my boy was taken into custody by police. And where is he? He did not return back. So police said, he is not here. We just make some inquiry and he returned back to his home. We are not aware where is your boy. She was shocked to hear these things. And then she thinks what to do now. Again, she make everywhere inquiry, nowhere they find it out. And then she thinks that we must take some action. And then they file case before the court and against writ of habeas corpus was filed before the court, and court orders state of Orissa to keep present this boy within 24 hours before the court. Court believes that what this lady says, that boy was taken into custody by police, is correct, and court orders state of Orissa that police that you please produce this son before the court within 24 hours. And then what happened? Everywhere search was going on, and the next morning police comes out with a story that this boy was found out on the railway track, his dead body. So they say he might have committed suicide. So postmortem was done, and in postmortem report, it was found out that this boy has faced torture. Police were in trouble, and court observed that there is a violation of human right when this boy was in custody of police, and next day when court passes order, then they are coming with this story. Then they were punished, police were punished. They were immediately, police officer was suspended, and for the first time, compensation was awarded to a mother. Even though we are aware that this compensation is not enough, one cannot return the boy, but for the first time, court observed that we must give compensation when it is a duty of a state to protect citizens and their rights. In one another case, Husainara Khatun versus Home Secretary State of Bihar, Supreme Court held that procedure prescribed by law for depriving a person of his liberty cannot be reasonable, fair, or just unless that procedure ensures a speedy trial for determination of the guilty of such person. Speedy trial is an integral and essential part of the fundamental right to life and liberty enshrined in Article 21. In Prem Shankar versus Delhi administration, Justice V.R. Krishna Iyer held that handcuffing is prima facie inhuman and therefore unreasonable, is over harsh and at the first blush arbitrary. So, handcuffing is not allowed for prisoners. The Supreme Court found that practice of using handcuffs and fetters on prisoners violating the guarantee of basic human dignity, which is part of the part of the constitutional culture in India and thus not standing the test of equality before law. So handcuffing is not allowed even for the prisoners. In Raghubir Singh versus State of Bihar, the Supreme Court expressed its anguish over police torture by upholding the life sentence awarded to a police officer responsible for the death of a suspect due to a torture in a police lockup. My dear friends, there are several cases pending before the State Human Rights Commission. 1 minute, just. There is a case of any kind of police torture, bad treatment given by the police officer, even prisoner can go before the court, before the commission, and commission conducts inquiry. Police officer is there now, so our Human Rights Commission member is a retired police commissioner, retired IPS officers are appointed so that inquiry is strictly done by them, and then they may award suspension of such police officer or any kind of punishment is levied on them. I advise Dr. Jitendra Aherkar to organize field visit of our student to our State Human Rights Commission, where you can actually go through the procedure, how they are filing cases, how they are making scrutiny of the cases, and you will get real experience. We are Department of Law, our all teachers are regularly going to the State Human Rights Commission and deliver lectures as they conduct training program for law students frequently. In Kishore Singh versus State of Rajasthan, the Supreme Court held that the use of third degree method by police is violation of Article 21. And D.K. Basu versus State of West Bengal, in this case also court stated that action of the state must be right, just and fair. Torture for extracting any kind of confession would neither be right nor just nor fair. So torture is not acceptable at any point of time, and prisoners also have their basic human rights and treatment, at least dignity must be respected. Dignity of the individual must be respected at any place. Number of rights were observed in this case, and Supreme Court laid down that in every police station they must keep these guidelines that which rights are available for prisoners, such as right to contact our friend relatives once any person is sent to custody, any inquiry is going on, right to legal aid. If any poor person is there, then they can get help of a legal aid. They can get help of legal assistant, lawyer, if anyone they want. Then if any person is taken into custody, this information must be provided from the police to their relatives, parents, family members. So if any person they caught and taken to prison and that person is from another district, then police inform another district police officer and they take help of NGOs to find out the address, because in district places there are villages, people are staying far away, and in such cases they are collaborating with NGOs and NGOs help them to find out person's address. In this way, they help each other, but try to provide all kind of assistance to prisoners. Prisoners also have facility of library in jails. They can read books. Even they can pursue their uh, any degree course, such as one of the prisoner has completed his law from the prison. They are allowed to appear in for exam. Prisoners food, quality of food is specified by the state, and every day this thing is reflected on the notice that how many calories are there, what kind of food is provided to them, and this notice is always there in local regional language so that everyone can understand. Like that number of rights are there. Even a medical assistant keep such field visits to prisons so that our students help any poor prisoner if they are helping them to prepare any kind of notice. If they need any help to file any say before court, our student helps. In that way, our students are very active. Also, there is another case of Sunil Batra versus Delhi administration, where it was observed by the Supreme Court that Article 21 forbids deprivation of personal liberty except in accordance with the procedure established by law, and curtailment of personal liberty to such an extent to be a negation of it which would constitute deprivation. So, as much as possible, prisoners' care must be taken. Another case is Olgatelis versus Bombay Municipal Corporation, where Supreme Court observed that from this judgment that sometimes courts have to broaden the scope of a particular article or section to make it beneficial for greater number of people. It is an important function of the judiciary to rightly interpret any section or article as to bring out the true meaning and broaden its scope. And Supreme Court observed that right to life includes the right to livelihood. My dear friends, if I'm going to explain, there are several cases and a full day is not enough to explain it, and my other colleagues are waiting. So once again, I appreciate uh, Dr. Jitendra Herkar, my colleague, Dr. Swati Rautela, for organizing this 1 week program of human rights awareness. And I'm sure Jitendra, Department of Law, always collaborate with Amlani College of Commerce for all kind of educational endeavor. My best wishes to all students and participants from other colleges for their success in future. Thank you once again, Dr. Jitendra and Dr. Swati. Thank you.
Thank you so much, ma'am, for your enlightening words. Ma'am, the serious thing is, whenever I get an opportunity to attend your lecture, I'm very sure about that I'm going to learn something new. That is a very exciting thing from your side. Thank you so much, ma'am, for enlightening us and our participants in the early morning so very well section. Thank you so much, ma'am. Thank you so much.
Thank you.
Now I request Dr. Swati Rautela, ma'am. She's the head of the Department of Law, University of Mumbai. Ma'am, I request you to take this section forward and for the kind things. Over to you, ma'am.
Yeah, thank you very much for inviting me. And first of all, I take this opportunity to thank Dr. Jitendra Ahirkar for coordinating with the Department of Law and coordinating with University of Mumbai. And I also thank my colleague, Professor Dr. Rajashri Varadi Madam, the former head of the Department of Law and yet head of the Department of Law, working with us together. So regarding human rights, regarding human rights, why do we give so much significance and importance to human rights? Why are they so important? The reason is to be determined, is to be understood. And human rights, basically, we say they are rights which are bestowed to us by nature. They are inalienable, they are inseparable. And the moment we are born, we have certain inherent rights. That means they are existing with us. That is right to live, right to move, right to have food, right to have shelter, and n number of rights as we perceive. And if we are looking into this history of rights, we have the natural rights, and prior to natural rights, we have the movements of paganism, or we have the Stoic movement, and even in the Roman law, the natural rights of individuals have been recognized. Also, if you look into the Hindu jurisprudence, definitely people have the right to survive, people have the right to learn, people have the right to live in the manner in which they wanted to live. But what happened when we have seen the era where there is the supremacy of races, where one who was very strong, who was very dominant, he thought he is the ruler, he is the master, and everybody is inferior to him. So there is suppression, and it is not only suppression from one country on another, but in the country from the kings upon their own people, and common people, they became subservient. They were being treated like slaves by their masters or by the kings, because in the Western philosophy, when we see the king is supreme, the king is receiving the powers from the God. So he is as God, and God cannot do any wrong. So God is the master. So the king is bestowed with all the powers, and church became the supreme power. Now, for these reasons, there is the period of enlightenment. And in elaborate manner, if we are going to look into this discussion, the historical perspective, my other colleague will be explaining to you in much more elaborate manner. But I'm just giving you a gist of history, what took place during the centuries. And every nation wants to dominate. So we have the English dominating on the American country, on the American continent for that particular matter. At that moment, America is not a country. The African continent, the Southeast Asian continent, and India also for that particular matter. Now, Japan is having its own policy of imperialism. The whole of Europe, for example, that is the supreme powers of the 16th and 17th century, if we see, that is England, France, Spain, Portugal, they all were traveling, and it is a race of dominance. It is a era of dominance. It is an era of conquering territories. So what is happening? People are being treated as subservient. People are being dominated. There is the king who is the master, and all are the working class. And the thought process which began after the era of Enlightenment or the Reformation movement in the France, it is leading to further developments. And in France, we see it is the French Declaration of Bill of Rights. These are the writings of Montesquieu. These are the writings of Voltaire and various other writers. And predominantly, when we look into it, is Hobbes, Locke, Rousseau, which propound that people were living in communities. And though they were living in communities, they are handing over their right to the state. And it is the responsibility of the state to take care of their people. But what is happening? Instead of state taking care of the people, the state is dominating. The state is committing atrocities. The state is collecting undue taxes from the people. So what happens? The poor remains the poor, and the rich becomes more and more rich and least bothered about whether the people have food to survive, whether the people have means to live, or whether the people have a shelter where they can survive. And eventually, when we look into history, we see the war for state. It continues with the First World War, the adoption of the United Nations, but United Nations is not a successful organization. And First World War, it begins with Germany. Again, a lot of, after the war is over, Germany loses, and a number of sanctions are imposed on Germany. And there comes the great gentleman, Mr. Hitler, Adolf Hitler, and eventually leading to Second World War, which is a great disaster, killing number of human beings and lot of lives throughout the continent. That is the reason it is being called as a world war. And the atrocities which were being committed on the prisoners of war, also on the people, and the atrocities committed by the Germans on the Jewish community, or if the English who were committing a number of atrocities on the African people, the Japanese who were wanting to have more and more colonies, they attacked the Pearl Harbor. And that is when America is entering into the Second World War, and the course of war changes. And we see that after the Second World War, looking at the deterioration, looking at the destruction, the nations, they do come together. And over here, it is the Americans with the Britishers, they come forward to prepare a document which is called as Universal Declaration of Human Rights for protecting and preserving the interest of common people. So ultimately, who is suffering? It is human beings who are suffering. So why should human beings suffer at the hands of other people? Now, these are the questions which will be coming into your minds, and definitely they should be coming. So what is international human rights law? It is the body of international law which is designed to promote human rights on social, social, regional, and domestic level. So it is not only international, but it is between the people, between the regions, and inside the nation also. So it is a form of international law which is based upon on treaty. So treaty is a document, is agreement between sovereign countries who are entering into this document as a party and seeking to have a binding legal effect, and through the customary international law also. So there are international human rights instruments, while not legally binding, but they contribute to the implementation, understanding, and development of international human rights law that have been recognized as a source of political obligation. So why should we be abiding these laws? You should have a doubt in your mind. Why should I follow a treaty? Why is it binding? So we also have to understand that today no nation is interdependent. We all are dependent on each other. We are having our requisites, we are having our limitations, and we have to borrow. Sometimes we may borrow goods, sometimes we may borrow technology, sometimes we may have to exchange goods, we may have to exchange services for that particular matter. So the interdependency on the nations, it is very much present, and political obligations have to be abided, have to be followed. So my topic over here was enforcement of human rights. Now, enforcement of human rights, definitely there are a number of treaties which are governing for enforcement of human rights, but it is the nations who have to take care that their domestic laws are in pursuant with the international human rights, so that the human rights in the countries can also be protected. So if we are looking into the perspectives of human rights, there are a number of functions where international human rights are taking place and they have to be applied. So there are situations where we have the refugees, their rights are to be protected. So you have the convention, that is 1951 Refugee Convention. We have the Convention for protecting the right of children, for protecting the prisoner of war, and the third Geneva Convention. So General Assembly of United Nations has adopted the Vienna Declaration and Program of Action in 1993, and for which United High Commissioners for Human Rights have been established. So we also celebrate the Human Rights Day in the month of December. And in 2006, the United Nations Commission of Human Rights was replaced with Human Rights Council for enforcement of international human rights law. Now, the changes proposed are structured and are reviewed from time to time, and United Nations have a program that is of sustainable development goal or Millennium Development Goal, that is targeting the promotion of legislation and policies towards reducing inequality. So sustainable development not at the cost of ecology, not at the cost of imbalances, not at the cost of destruction or deterioration, but it is preservation, it is restoration, it is you do utilize the nature, but do not destroy nature. Do not create imbalances in the society. So let us move to the main document, that is Eleanor Roosevelt and her committee and team of members. They are drawing this document which is called as Universal Declaration of Human Rights in the United Nations General Assembly, and to create a binding international human rights law. And UDHR is evidence of customary international law. UDHR has become authoritative law with the human rights perspective, and it has been providing the basis for subsequent international human rights instruments. Now, what are these instruments? What are these documents? So in 1996, the two wide-ranging covenants which have been a part of the International Bill of Human Rights, that is the International Covenant on Civil and Political Rights, and International Covenant on Economic, Social, and Cultural Rights. Now, why these two documents are important? Civil political rights. You can develop, you can grow in the society when you have the right to decide. You have the civil right, you have the political right to have your own government, to form your own government, the right to vote, the right of a person to participate in election, to be elected, or to have the legislations made. So this covenant is very, very important, seeking to it that the governments have free and fair elections, democratic form of governments where people also participate in the forming of their governments and participate in the making of government and working with the governments. Now, economic, social, cultural rights, these are the basis for development and growth. How do I grow? How do I develop? When I have some work, I can earn. Okay, so economic right to have a living, right to live with dignity. It's only when you work, when you earn, you can live with dignity. Social rights, right to move around with your people, right to participate in cultural activities, right to participate in culture, or to have your own culture, or to have your own social cultural gatherings, or the manner in which you want to follow your religion, manner to participate in religious or social gatherings, or to do the worship. So these treaties are very, very significant globally, and they are generally known as human right instrument. Instrument over here means a treaty. Instrument over here means a document. Now, what are the other treaties which are very, very significant? It is the Convention on the Prevention and Punishment of Crime of Genocide. Genocide is mass killing. So during the Second World War, we saw there was mass killing of the Jews. We also saw in various other countries, the practices were being formed by government. And this convention is adopted in 1948. It is to prevent and punish the people who are committing the offenses of genocide, that is mass killings. Then convention relating to the status of refugees, which is adopted in 1951 and entered into force in 1954. Refugee status, many people are left homeless. Why they are left homeless? Because of war, because of natural calamity, because of a coup, because of a revolution. Where do they go when they lose everything? Who is going to accept them? This was the state of affairs during the Second World War, and today also in the Middle East, when we see where a number of Syrians, number of Palestinians, they do not have home, and they were moving into the territories of Europe, and now Europe has also declined that these people cannot be accepted as, no longer can be accepted as refugees. But where do these people go? Who is going to give them the protection or the basic right to live? So this is the convention for protecting the interest and the status of refugees. Then you have the Convention on Elimination of All Form of Racial Discrimination, adopted in 1965 and entered into force in 1969. All form of racial discrimination. Now, elimination of racial discrimination, it is very, very difficult. Till date, we have already faced the consequences, where we saw Hitler saying that he belonged to the supreme Aryan race and no other race could survive, could continue. So there was mass extermination of the Jews. And this is also happening today, where one race feels we are predominant and others are inferior or do not have any kind of right. So this convention, it is trying to eliminate the forms of racial discrimination. Then we have the Convention on Elimination of All Form of Discrimination against Women, CEDAW, entered into force in 1981. So a lot of discriminatory practices are inflicted on women, not only in India, but it is a global phenomenon. And this convention tries to eliminate the various forms on description on women. We have the United Nations Convention Against Torture, Convention on Rights of the Child, because the interest of the children have to be protected. Children are the future. Children are assets. So if children are not protected, children are being taken away as war criminals, or are being punished, or are being tortured, no nation can progress, no nation can develop. So this convention tries to protect the interest, protect the rights of the child. You have the International Convention on Protection on Right of All Migrant, people moving from one territory to another territory, another nation, worker and members of their family. Then today we have these conventions, that is the right of persons with disabilities, the International Convention for Protection of All Persons from Enforced Disappearance. Many people are lost. They cannot be found. Their families wait for them for years and years. Where are they? Where have they lost? So this convention is there to protect the people from enforced disappearance. So there are regional treaties, that is in particular regions, these treaties have been adapted. So you have the African Charter on Human Right and People Right, adapted in Africa in 1981, and it came into force in 1986. The American Convention on Human Rights, the European Convention of Human Rights for Europe in 1950 and 53. Then we have the Organization of American States and Council of Europe, like the United Nations. They have adopted their treaties and have various dialogues of economic, social, and cultural rights, in addition to the conventions with civil and political rights. The European Social Charter for Europe of 1961 came into force from 1965 and has been created in 1995 under the additional protocol and is in force from 1998. Then the Protocol of San Salvador to the ACHR for Americas of 1998. Then human rights in Africa, the African Union is supranational union consisting of 55 African countries. It has been established in 2001, and the African Union's purpose is to help secure Africa's democracy, human rights, sustainable economy, and bring an end to intra-African conflict and create effective and productive common market. Now we also have the regional treaty, that is the African Charter on Human Rights, Human and People's Right, that is in the region's principal human rights instrument, which has emerged under the aegis of Organization of African Unity, replaced by African Union. And the intention is to draw up African Charter on Human Rights and People's Right. The charter has been approved in OAU's 1981 assembly. Now, African Human Rights Day, it is being celebrated. Then African Commission is there on Human and People Right. It is a quasi-judicial organ of the African Union with the purpose to promote, protect human rights, collective rights of the people throughout African continent, with interpreting the African Charter on Human and People's Right. Basically, it is for promoting human right, people right, protecting human and people's right, interpreting the African Charter on Human and People's Right. So these goals are there. The Commission is mandated to collect all documents, undertake study and researches of African problem in the field of human and people's right, organize seminars, symposia, conferences, disseminate, that is to forward information, encourage national, local institutions concerned with human and people's right, and should the case arise, give its view or make recommendations to the various governments. Now, creation of African Court on Human Rights and People Right under a protocol to the Charter, which is adopted in 1998 and entered into force in case if offenses against humanity, against human rights are committed, then these courts are empowered with the power to give redressal to the victims. So in a July 2004 decision, the African Union Assembly has resolved that the future Court on Human Rights and People's Right is to be integrated with the African Court of Justice. So the Court of Justice of African Union, it is intended to be the principal judicial organ of the Union. Although it has not yet established, it is intended to take over the duties of African Commission of Human and People's Right, as well as to act as Supreme Court of African Union, interpreting all necessary laws and treaties. So the protocol establishing African Court on Human and People's Right is entered into force in Jan 2004 and is merging with the Court of Justice, and the protocol establishing the Court of Justice will come into force when it is ratified by the 15 countries. So we have the Inter-American Commission on Human Rights, and this is called as Organization of American State. Now this is after 1990s, after the end of the Cold War and return of democracy to the Latin American countries, and with the thrust of globalization, the new priorities have been established over here, and these priorities are strengthening democracy, working for peace, protecting human rights, combating corruption, right of indigenous people. Who are indigenous people? They are the people who are there from antiquity. They are living through generations and generations, and they have their rights. So many of these indigenous people have been killed, have been destroyed, but yet the North American original people, or the people in India, that is even in the Dravidian regions or the tribal regions, originally belonging to a particular tribe, to a particular community, we call them to be indigenous people, their rights, and promotion of sustainable development. So we have the Inter-American Commission on Human Rights. It is autonomous organ of the Organization of American States based in Washington, D.C., along with the Inter-American Court of Human Rights based in St. Jose, Costa Rica. It is one of the bodies comprising the Inter-American System for Promotion and Protection of Human Rights. And there are 3 documents which take care of this. It is the OAS Charter, the American Declaration of Rights and Duties of Man, the American Convention on Human Rights. Now, American Court of Human Rights, it is established in 1979 with the purpose of enforcing and interpreting the provision of American Convention on Human Rights. Now, the significant system which you have to look into over here, it is the European system, and it is the Council of Europe, which is founded in 1949. It is one of the oldest organization working for European integration, and it is international organization with legal personality recognized under the public international law, and the seat and the main office, it is in Strasbourg in France. Now, Council of Europe, it is responsible for both European Convention on Human Rights, European Court of Human Rights, and these institutions bind the Council's member to a code of human rights which, although strict, is more lenient than that of United Nations Charter on Human Rights. Now, the Council, it is also promoting European Charter for regional or minority languages, the European Social Charter. Membership is open to all the European states which seek European integration, and they accept the principle of rule of law and are willing to guarantee democracy, fundamental human rights, and freedoms. So the Council of Europe, it is separate from European Union, but the latter is expected to accede to European Convention on Human Rights, and the Council also includes all member states of European Union. The EU has a separate human right document, that is the Charter of Fundamental Rights of European Union. Now, the European Convention on Human Rights, it is still from 1950. It is defined, it is guaranteeing human rights, fundamental rights in Europe. There are 47 member states of the Council. Since the day in Europe this convention has been signed. Then there is the Committee for Prevention of Torture, which has been established. And the Council of Europe has also adopted the Convention on Action Against Trafficking in Human Beings in May 2005. Protection against human trafficking, sexual exploitation. The Council of European Convention is on protection of children against sexual exploitation and sexual abuse, and the Convention on Prevention of Combating Violence Against Women and Domestic Violence. So you have over here the International Court of Justice with jurisdiction to deal cases brought by individuals rather by the state. And early in 2010, the court had a backlog of 120,000 cases and a multi-year waiting list. So about 1 out of every 20 cases submitted to the court is considered admissible. In 2007, the court has issued 1,503 verdicts. At the current rate of proceeding, it will take 46 years for the backlog of matters to be cleared. Now, currently, we have the International Court to administer international human rights. It is a quasi-judicial body, but it is existing under the United Nations Treaties, that is the Human Rights Committee under the International Covenant on Civil and Political Rights. We have the International Criminal Court. It is having jurisdiction over the matters in relation to genocide, war crime, crime against humanity, European Court of Human Rights, and Inter-American Court of Human Rights for enforcing regional human rights. And United Nations human rights bodies do have quasi-legal enforcement mechanisms. These include the treaty bodies attached to 7 currently active treaties and United Human Rights Council, complaints, procedure with Universal Periodic Review, and United Nations Special Rapporteur known as 1235 and 1503 respectively. So enforcement of international human rights, it is responsibility of a nation state. It is primary responsibility of the state to make human right of a citizen a reality. So many human rights, they are difficult to be enforced legally due to absence of consensus on application of certain right or the lack of relevant national legislation or the bodies empowered to take legal action to enforce them. But in 110 countries, National Human Rights Institution, that is NHRIS, they have been set up for protecting, promoting, monitoring human rights with the jurisdiction in a given country. And we have the Paris Principles. They are defined at the first international workshop and national institution for promotion protection of human rights in Paris from 7th to 9th October 1991. So universal jurisdiction, it is a controversial principle in international law where state claims criminal jurisdiction over the people whose alleged crimes were committed outside the boundary of the prosecuting state, regardless of nationality, country of residence, and other relationship to prosecuting country. The state backs its claim on the ground that the crime committed is considered a crime against all, which any state is authorized to punish. The concept of universal jurisdiction is therefore closely linked to the idea that certain international norms are erga omnes or owned to the entire world community, or the concept of jus cogens. So in 1993, Belgium has passed a law of universal jurisdiction to give its courts jurisdiction over crimes against humanity in other countries. 1998, Augusto Pinochet was arrested in London following an indictment by Spanish judge under the universal jurisdiction principle. The principle is supported by Amnesty International and other human rights organizations, which believe that certain crimes pose a threat to international community as a whole, and that community has a moral duty to act. Then others do argue that there is a widespread agreement that human rights violation and crimes against humanity must be prosecuted. They have been hindered active consideration of proper role of international courts. So there has to be universal jurisdiction risk, creating universal tyranny. Okay, so these are the sources of international law. So they are the traditional sources. We have the principal sources and subsidiary sources. So under traditional sources, we have the treaty, we have the customary rules of international law and general principles of law. Subsidiary, if we are looking into, we have the judicial decision and writings of most highly qualified scholars and writers. Now, 38(1) of the Statute of ICJ propagates the 5 traditional sources recognized under international law, and they are the treaty, that is international agreement concluded between nations or state or parties. It may be bilateral, it may be multilateral, and may be called as with any of the name. You may call it to be a charter, you may call it to be convention, you may call it to be a covenant or a protocol. Now there can be ratification of certain treaties. There can be domestication, that is effect of domestication of a treaty into a national law. The case study you can study, that is Agbakoba versus Director of SSS and Abacha versus Favhimni. Then there is international human rights. It is a branch of public international law aiming to protect internationally guaranteed right of individual and groups against violence by the state. Now, if we are looking into the international human rights, then it is first generation human rights, second generation human right, and the third generation human right. Now, first generation, it is granting the civil and political rights, that is the state, the need of a welfare state to protect the interest of the people, people to participate in democracy, democratic form of government. So justice, freedom, liberty, equality, this all are the principles over here which are being recognized and allowing people to grow. Second generation, it is economic, social, cultural rights, which is a must. It is only with economy, prosperity, it is only with peace in the region or in the state people can grow, people can develop. Trade can grow, trade and commerce. And earlier we have the barter exchange, but today in trade we have transfer of technology, we have transfer of communication, transfer of services, and the advent of globalization. Distances have been reduced. Trade is given more significant importance, and the most significant treaty over here is General Agreement on Trade and Tariff, and the emergence of the World Trade Organization and World Intellectual Property Organization. So the third generation of right, it is the vulnerable groups, the weaker sections, that may be women, children, the scheduled caste, scheduled tribe, minorities. So protecting their right, their interest, promoting their interest. A principle of positive affirmation or positive discrimination can be followed by the state. That is the policy of reservation for uplifting the weaker sections of the society. So we have number of constitutional provisions. Then we have environmental development rights, protecting the environment, sustainable development, biological convention on biological diversity, convention on climate change. Then you have the teams which are to take care during the event of cyclone, storm, or any such natural calamity or disaster where people, property have to be protected, cattle have to be protected. So environmental development right, it is not only by destroying the environment, but it is also to nurture and protect environment for future generations to sustain, for future generations to grow. So if you protect environment today, you stop cutting the jungles today, in future it will be there for the communities which are, for the generations which are going to live, for the generations which are going to continue. Then civil and political rights, it is the right of migrants, refugees, people who are displaced and who are becoming migrants due to displacement, right of women and children. Then economic, the bifurcation over here, again, it continues, that is people who are living with disabilities or living with HIV, AIDS, or certain difficulties. Then there are victims who are, because of trafficking, they have been picked up and they are sexually exploited, they have been sold, or they are victims of crime, that is genocide, mass killings, victim of war crimes and abuse of power. Then interest of minorities are to be protected, and people with disability, people who are old, they also, and their interest also is to be protected. Then the last column under the economic and social cultural right over here, it is self-determination, work, employment, social security, family protection, assistance, adequate standard of living, gender equality, health, not only physique, but it is physical, mental, social, reproductive and sexual health, education and cultural life. Self-determination, that means people have the right to determine they belong to a particular region, they belong to a particular territory. So under self-determination, we have the new states which have come, that is the state of Chhattisgarh, the state of Telangana, the state of Uttaranchal, where the people want to determine their identity. And in Maharashtra, there is still the a debate under this is going for the Maharashtra with the state of Vidarbha. Okay, so social security benefits, that is with retirement, also to be given to the people, or certain benefits which are there, that is regarding to the health. Like we had the mass campaign for vaccination of people, and it was funded with the government, and where it was not funded, even then where subsidy was not given over here, even then it was at a meager rate, so that everyone could be vaccinated. So health was given a priority, and good standard of living, gender equality, men and women both work, and equal payment for equal work. Then ethnic, linguistic, cultural, political, religious, racial, sexual and indigenous people and their rights to be protected. So after 1945, after the Second World War, This phenomenon has left to the new branch of international law, and we have the United Nations Charter coming of 1945 and Universal Declaration of Human Rights coming on December 10, 1948. And 1966, we have the International Covenant of Civil and Political Right, that is an economic, social, cultural right. Then African Charter on Human and People, and various other regional instruments, European Convention on Human Rights, and international human right is said to have impacted on the concept of legal personality in international law, which pre-Second World War excluded individual human beings. And this was done explicitly recognizing individual human being as legal persons. So international human right law has rejected the claim of state under the notion of sovereignty, of exclusive domestic jurisdiction in human right violation. So the three perspectives for enforcement and monitoring mechanisms over here are the United Nations Treaty monitoring body, regional human rights bodies, United Nations based bodies. So over here you have the ICCPR, Committee on CCPR, ICESCR, and the committee over there. Then ICEDR, the United Nations Committee on CEDAW for protecting the right of women, the United Nations Committee on protecting the right of children, and also the Committee for protecting other interests. Then you have the Economic and Social Rights, United Commission on Human Rights, United High Commissioner for Human Rights, and Commission for Universal Peer Review. So time to time, the review has to be made into the functioning and enforcement of this legislations so that these tools, these mechanisms can be implemented in effective manner. And in Africa, we have the African Commission on Human Rights and People Right. Africa, we also have the African Court of Human Rights. Europe, you have the European Court of Human Rights. America, you have Inter-American Commission on Human Rights and Inter-American Court of Human Rights. So international human rights law, there is to be a domestic implementation of international regional human rights instrument and ratification of human rights treaties, incorporation of the national laws and enforcement in a court of law, and monitoring compliance by National Human Rights Commission and Public Commission, Consumer Protection Act and Consumer Protection Codes, etc. So we can see that though some nations may want to accept, some may not want to accept, but number of legislations for protecting the human rights have been widely accepted. And human rights are understood to represent individual and group demand for political power, wealth, enlightenment, various cherished values, capabilities, and the most fundamental of which is respect and its constituent element of reciprocal tolerance, mutual forbearance in the pursuit of all other values. So human rights imply claim against person and institution, impeding the realization of values and capabilities. And human rights also qualify state sovereignty, power, sometimes expanding the latter even while circumscribing the former. So human rights are said to qualify private sovereignty, business enterprise, protecting family member from domestic violence, and holding non-state terrorists across to count. So human rights are commonly assumed to refer in vague sense to fundamental as distinct from non-essential claim of goods, and they reflect varying environmental circumstances, differing worldviews, and inescapable interdependencies within and between different value or capability. Then the most assertion of human rights are freedom from slavery, genocide, torture, and qualified by the limitation that the right of individual or group in particular instances are restricted as much it is necessary to secure comparable right of others and aggregate common interest. So it is a right to be determined to be a human right. It is understood that quintessentially general or universal in character, and in some sense equally possessed by all human beings. And all these postulates, they raise questions. What does it mean to have a right? It is fundamental. According to what standard? According to what according to the distinctiveness from legal right. So non-justiciable right, whether they are there, if there, how they can be protected. And according to the criteria, does the right of one person or group of people give way to the right of other? What happens when individuals and group rights collide? Or how are the universal human rights to be determined? So So with the advent of modern history, the content of human right today, it is broadly defined, not with any expectation that the right is associated with one generation or it is outdated, but it is there and it is expensively supplemented. And the history of the content of human right also reflects revolving and conflicting perceptions of which values and capabilities stand at all different times and through different lenses, and simultaneously they are existing, they are functional, and these dynamics are reflected in the rising consensus that human rights extend to the private as well as to public sector, that is the non-state as well as the state actors. They must account for their violation of human right. Similarly, reflecting is the continuing pressure for human right evolution in the current suggestion that there is existing fourth generation of human right, that is of women, and intergenerational right, that is the right of future generations, including existing children amongst the others. So the content of human right, it is broadly defined, and the ongoing debate about the nature and content of human right reflects, after all, a struggle for power and for favored conceptions of the good society. Yeah, so this is the state of affairs of human rights student. I have given you the global perspective into the same. Now, for treaties, India has also acceded to the number of treaties, and we are adapting, we are following, and yet there are limitations. We have the National Human Rights Commission. We also have the State Human Rights Commission. And regarding more on evolution and the historical perspective of human rights, my colleagues will be explaining to you. And there are various other topics which are very, very significant. That is the human right, education, then right to medicine, with vis-a-vis the patenting. Okay, so when drugs are patented, do common man have the right to medicine? And if it is, then how it is to be imparted? And treaties part, convention part, I have completed, but I think one of my colleague will also be discussing in a different manner regarding the treaties, their functionality, their adaptation. And one of the teachers, they will be discussing with you people, that is the issues and challenges which have evolved during the centuries, during the period, and how they are going to be resolved, or the manner in which the states, the governments are looking forward for resolving this contemporary issues and challenges into the human rights. So with this, I will like to stop my presentation, and I will request Jitendra sir to chair now the session. Hello.
Yes, ma'am.
Yes, Jitendra sir, if they want to ask something, they can ask, because I would like to stop my session over here now.
They are all muted and few are on YouTube channel.
Okay, okay,
Yeah.
sir.
So girls, with this, we'll end the session here. And I thank Dr. Swati Rautela, ma'am, at Department of Law, University of Mumbai, for the wonderful and expertise session on certificate course on human rights. Tomorrow again, we'll be back at 11 a.m. and we'll have session of Dr. Alka Patil, ma'am. And consecutive days, we'll have the sessions which have been lined up for you. Today's day was a bit lengthy because of the inaugural function, as well as the two speakers for today's program, Dr. Ayushi Varadi and Dr. Swati Rautela, ma'am. But from tomorrow, we have a single session of one teacher each, and we'll see to it that we will cover all the topics pertaining to human rights, and hope we'll have a good session on last day, that is the validatory session on Friday, where you will be able to speak with the fellow dignitaries, and we can also have some brainstorming session. Thank you so much.
Yeah. Thank you, Jitendra sir. And thank you, students, for joining. Please feel free, write down your questions and queries so that we can be meeting you on the last day, and we can have a discussion into the same, and we can try to resolve the same. So thank you, Rajashri ma'am. Thank you, Jitendra sir. Thank you, Alka madam. And with that, we will take your leave. Thank you all for the day.